evening. Mr. Justice B.R. Gawai, Chief Justice of India designate. Thank you for your kind words, and I hope I'll change to that extent. How do I begin? My, I began my practice from the district courts. I'm very proud of that. But there is another precursor to it. As a youngster, though my father was a judge, I hardly visited any courts. I'd never been to a court except seeing Tisazari courts from the outside. So when we were doing laws, one day we decided we'll come to the Supreme Court, and unlike today, you could just walk in. There were no passes, nothing. And Indian Express case was going on. And Mr. Lal Narayan Sinha was arguing that matter. And I wondered, I said, how can anybody so different from what we have seen in the films? So different. He used to argue very simply, not raising his voice very plainly, very calm, composed manner. So that was my first introduction to real court. It was in the Supreme Court of India. Then when I finished my education in the law faculty, I had, not many people know, I for about maybe 3 weeks or 2 weeks, I don't remember now, I worked in the office of Mr. P.H. Barik, the advocate on record, in his bar. And then my journey began in 1983. And it's ending at the same place where I started, the Supreme Court of India in a way, because I commenced my first court appearance, not as a lawyer, but as somebody who's watching the court proceedings was here. And now I retire, perhaps, I'm very happy to say, as the Chief Justice of India. When I got this invite a couple of weeks ago, I was thinking, what should I say? As judges, we tend to somehow preach a lot. I thought I should not do that, but then I realized it's impossible. As judges, we normally come to that thing doesn't go out of us. One thing I still feel we haven't really mastered the art is the art of drafting. I feel that there is a huge effort which is required. We must adopt the following, the dictum, less is more. The less you say, the shorter the petitions, the crisper the petitions, the clarity the petitions have, it is far more beneficial both for you as well as for the judges, because as judges we exactly know what is the point being argued. I'm reminded of an instance where I drafted a petition, objections to an award which were to be filed in a European country. I was already told, please make it very brief, don't make it too many grounds. So I drafted about 8 or 9 grounds instead of normally 30, 40 grounds that we draft. And in the morning I got a reply from the advocate who was to file that. I've reduced it to 3, the cost will be higher. So that's extreme. I don't agree with that. But nevertheless, I think we have to have more crisper petitions. It helps us read the files more easily. And as a judge, I can tell you, your 50% work is done if the judge who's read the file feels there's a point of view which requires consideration. But if you make it too prolix, too elaborate, invariably we miss out the real point which is sought to be raised. I also want you to see you arguing the matters. Don't depend upon seniors. I think by and large, most of us prefer a person who's well conversant with the facts of the case. You have direct access to the litigants. Litigants talk to you. You prepare the brief, you study, and then you brief a senior. Why don't you come and argue in the court itself? I think that is one aspect which I felt. And most of us do give a little more leeway and more time to a junior or an advocate. I won't like the term junior as such, more time to an advocate on record, because we feel that sometimes he may not be able to express it that fast in a short time. But please do appear in the court and argue the matters. There's these days a lot of conflict which is going on, whether you should be specialized or versatile. I also had that because I started off in between, I shifted completely to income tax. I personally believe your domain skills, subject matter skills are very important. In times to come, it's not your oratory skills which will carry you forward, but which will make a good lawyer. It's your subject matter and domain skills. Coupled with that is your mastery of the facts. Most of the cases, unlike you, are not decided on law. Almost 70-80% cases are decided on facts. So having full knowledge about the facts. I find it very odd when during the course of arguments, when you pose a particular question and the counsel who is arguing looks down to the associate and says, what is the factual position? That's not done. Facts will take you, every case doesn't have to be decided on huge constitutional principles. You can build on those constitutional principles, but first you must have the facts with you. That is one area where I think all the youngsters will have to take lead. The second area which is going to become the mainstream, perhaps not in the Supreme Court, but in most of the courts, is mediation. Most of the disputes will ultimately, if we first mediate it, that's the aim and object of the Mediation Act. That's why we started off with the online mediation training course, which I'm told has become fairly popular, because that will cut short a lot of time which is spent in court. So I wish a lot of you should take up that online mediation training course, and also go for higher courses in mediation. There's another aspect which I feel, which is somewhat requires attention, is mentoringship. When we joined as a lawyer, I remember you'd always face a lot of difficult questions and issues, and then you look up to your seniors to tell you the solution. Often they'll tell you a solution, but invariably they would leave some gaps because you have to then fill them up. Mentoringship is very important. I think anybody who's done about 15 years, 10 to 15, 20 years must open up the doors. I think SCORA should take that lead. Wherever they feel that any junior has some issues and questions, why don't you give your names? Then say people can walk up to us, talk to us, and we can give their opinion. Let me share with you, my office, which if I have an office or whatever it is, will be always open. I like all of anybody I like to help out anybody who has some legal issues and questions. If he finds that I can help him out, or I will be able to give some advice, it will be my great pleasure if anybody walks in and talks to me. Let me end by just quoting from a few words of Ruth Bader Ginsburg. Lawyers have a license to practice law, a monopoly on certain services. But for that privilege and status, lawyers have an obligation to provide legal services to those without ability to pay, to respond to the needs outside themselves, to help prepare tiers in their communities. That should be the goal of all of us. As I prepare to demit office, I do so with deep faith in this institution, the Supreme Court of India. The Supreme Court is a forum of conscience, of constitutional values, and of immense responsibilities. While we as judges pronounce judgments, it is lawyers who carry the case from the first breath to the last word. The advocates on record carry it even further. From the first call to the final order, you are the thread holders that holds the institution together. Carry on that role with pride, with care, and with sincerity. Thank you, and Jai Hind.